Ladies and gentlemen, my name is Isaac Christopher Lubogo, and today I would like to take you through what I call militarized justice, the constitutional struggle over civilian trials in Uganda's military courts. This has caused a lot of challenges for both the state, the legislature, but also the judiciary inclusive. And the issue of prosecuting civilians in military courts has actually been a contentious legal and even constitutional matter in Uganda, marked by significant judicial decisions and even legislative responses. So I would like to offer some kind of insight in light of the challenges that have befallen our country. First of all, let me begin by giving a historical context and in light of judicial precedents. The debate basically centers on whether the military courts, established primarily for disciplining armed forces or armed forces personnel, should actually extend their jurisdiction to civilians. And this practice has actually faced numerous legal challenges. Let's begin by 2009. 2009, the Court of Appeal decision, the court ruled that military courts should not have jurisdiction over civilians, emphasizing that such trials contravene constitutional provisions. Yes, that is something we need to comprehend from the word go. I would also like to argue in light of 2022, in light of the Constitutional Court ruling in retired Captain Amon Biarugaba and others versus the Attorney General. The court declared that military courts lack jurisdiction to try civilians, reinforcing the principle that civilians are actually entitled to fair trials in civilian courts. So that becomes, again, extremely important for us to understand from the word go. And then just recently, as far as January 31st of 2025, the Supreme Court judgment, the Supreme Court unequivocally held that prosecuting civilians in military courts is unconstitutional. And this landmark decision mandated the immediate cessation of all civilian trials in military courts and ordered that the transfer of pending cases to civilian judicial systems, in as far as civilian entities were concerned. Not so. And so the question, or perhaps the bigger development, is in recent development and in light of the executive responses, we have had a lot of pulls from both fronts. Yeah. So despite the Supreme Court's ruling, the executive branch has actually expressed intentions to amend the UPDF, okay, the Uganda People's Defense Act, to reinstate military court jurisdiction over certain civilians. And that's a debate that we want to contextualize and as far as what we're talking about today. Now, no doubt that the NRM Parliamentary Caucus meeting, as of February 21st, 2025, members of the ruling National Resistance Movement, the NRM, convened to discuss proposed amendment to the UPDF Act. Yes, and the key proposal advocates for civilians found in illegal possession of specified arms to be tried initially by military courts with provisions of appeal in civilian courts. And that is something they want to bring in light of an amendment. Yes. And then what was the Attorney General's position? The Attorney General's position, as far as is concerned, the Attorney General has indicated that government is actually implementing the Supreme Court's orders by seizing all pending civilian trials in military courts. However, the proposed amendment suggests a nuanced approach, potentially allowing military trials for civilians under specific circumstances, such as possession of military-grade weaponry. And that is the operative word here, military-grade weaponry. In a with time, we shall comprehend and understand what that means. Now, as far as implications and analysis is concerned, I will probably offer the following analysis in light of that particular, challenge that we're having. The executive is moved, for example, to amend the UPDF Act raises several constitutional and even legal considerations. Yes, and these are some of the things that I would like to shed light upon. Number one, the argument of separation of powers. Yes, amending legislation to counteract a supreme ruling may actually be perceived as undermining judicial authority, potentially disrupting the balance among government branches. And that is something very, very important for us to comprehend and understand in as far as this particular issue is concerned. Yes? Now, let's also argue in light of the right to fair trial. Yes, international human rights standards and Uganda Constitution guarantee the right to a fair trial before an independent and impartial tribunal. Yes? So trying civilians in military courts, which are designed for disciplinary proceedings within the armed forces, may compromise these rights. So that is something, again, you cannot take away. in light of an analysis as far as this debate is concerned. Now, we could also say that legislative constraint, for example, if you look at Article 92 of the Ugandan Constitution, it prohibits Parliament from passing laws that alter or negate judicial decisions. So the proposed amendment could actually face legal challenges on this basis because, I mean, Supreme Court has pronounced itself. So that can be something that, the courts have to deal with at a later time. Yes? So while the government cites national security concerns to justify, for example, trying civilians in military courts, such actions must actually be carefully weighed against constitutional, mandates and international human rights obligations. Upholding the rule of law and ensuring the independence of the judiciary are actually paramount in maintaining just and even democratic society. So that is fundamentally important, and we cannot take that away in light of the discussion we're having today. Now, I would like also to give an analysis in terms of the constitutional and legal challenges of challenging civilians in military courts. First of all, let me chronologically argue by way of referencing in terms of case law, but also in terms of jurisprudence, in terms of the recent development regarding the amendments to the EPDF Act. Yes? Let's first of all argue in terms of the origin. The origin and first of all justification of the military jurisdiction over civilians. Where does that get its bearing, its origin in light of the discussion we're having today? Military courts exist primarily to maintain discipline among armed forces personnel. Yes. However, some governments have actually extended their jurisdiction to civilians, often citing national security threats. Yes. And also things like terrorism and illegal possession of military hardware. Yes. And in Uganda, the UPDF Act 2005, for example, granted the General Court Martial the power to try civilians under certain circumstances. Yes, and this is something that that we need to we're debating about in light of what we're talking about. Yes, and historically, by way of justification, the government initially, justified trying civilians in military courts as a means to handle crimes involving military weapons, things like terrorism, for example, espionage, in terms of spying, in terms of arguing that civilian courts were actually equipped to deal with such cases efficiently. So that's why they argued in terms of a justification for doing what they're doing. But you see, when you do that, then you force substantive criticism. Over time, legal scholars and human rights organizations have actually argued that military courts lacked impartiality in terms of independence when handling civilian cases. And the concern was that military tribunals, being part of the executive, for example, in light of the Ministry of Defense, could actually be used to silence political dissidents and even, suppress opposition. And that is something that worries the nation in light of that particular, the discourse, if you like. So even as we argue that, we could also argue in terms of landmark judicial decisions on military trials, for example, as far as civilians are concerned. I will provide some that come to mind in light of shedding more enlightenment in terms of the discussion we're having today. Ugandan courts have consistently challenged the legality of trying civilians in military courts, and I'm going to chronologically review some of these cases and also try to lay bare some of the challenges that befall us as a nation. Let's begin with high court decisions, for example, because courts of first instance in terms of originality. The argument of the high court decision in 2006. The Uganda Law Society versus Attorney General, for example, that particular case, the High Court ruled that military courts had no jurisdiction over civilians, and that any trial of civilians in such courts violated Article 28, Subarticle 1 of the Ugandan Constitution, which guarantees a fair trial before an independent and an impartial tribunal. So that, again, is extremely important as far as that is concerned. So even as we begin to smuggle or struggle to do these things, those must come into place. We need to be aware. We need to be alive to the fact that court decisions have actually taken root in this country. Let's talk about Court of Appeal decisions, for example. In 2009, the Court of Appeal reinforced the High Court ruling by emphasizing that military courts actually lack the independence and the competence to try civilians fairly. That is something, again, you cannot take away in light of the jurisprudence that has been occurring in this particular direction. However, despite these rulings, the executive has continued to charge civilians in military courts, prompting further, legal challenges. A good example is the one that is just happened recently in light of Dr. Kizza Besigye. So those are some of the things that you need to open your minds up. But then also, if you look at 2022 Constitutional Court decision, the case of retired Captain Amon Biarugaba versus Attorney General, that is another one that has also substantive jurisprudence in light of this particular debate that we're having today. The Constitutional Court declared Section 119, Sabbatical 1G and H of the UPDF Act as unconstitutional. Yes, and is unlawfully extended military jurisdiction over what? Other civilians. So for them, they are saying, listen, we are strictly saying this should apply to what? Military personnel and not civilians in that aspect. So the ruling directed all pending cases involving civilians in military courts to be transferred to civilian courts. And that is something that was celebrated and well taken over by quite a number of individuals in this country. But when you look at also the 2025 Supreme Court judgment, particularly in light of what has just happened recently, on January 31st, yes, 2025, the Supreme Court issued a final ruling prohibiting the trial of civilians in military courts. I don't know if you remember that, but I'm sure you do remember that because some of this information is still live on our fingertips. Yes, and the ruling basically reinforced that only civilians serving in the military or directly engaging in military operations could actually be tried under a military law, and that is something fundamentally important. Whether we like it, whether we don't like it, the law is the law, and sometimes we have to be interpreted in black and white, although it's sometimes interpreted in shades of gray. Now, the immediate implication of over 250 civilians actually who are facing trial in military courts were said to have their cases transferred to these so-called civilian courts, and that is something that we are yet to see and witness. Rarely, there are some that are taking place, just like the one of Dr. Kizza Besigye. Not so. Now, also important to note is that the recent development and the executive responses, despite the Supreme Court ruling, the executive arm of government has actually been exploring ways to amend the UPDF Act to retain some form of military jurisdiction, over civilians. And that is the challenge that seems to be biting and disturbing both ends. Yes, the military, on the other hand, together with the executive, feel like, we need to get hold of these guys who assumedly may have access to these weapons that are a privy to the military. But so the proposed amendment to the Military Act, as far as 2025 is concerned, is in light. For example, government has actually proposed several changes in light of the UPDF Act, including some of them, as we are reliably informed, in terms of some of the things to make some substantial inclusion. For example, reintroduction of military trials for civilians found in possession of military weapons. Yes, and this is the thing. This is where whereas civilians are not entitled really, except with permission of the IGP, and to have weapons, especially guns like pistols and stuff like that. That exclusivity of these weapons are actually only to the military. Okay, and also they want to make allowing civilians accused of crimes against national security to be tried in military courts. That's a dicey one. Yeah, how are you gonna? What's the yardstick of saying this guy is accused of a national security instance, defined for me national security, and then creating a hybrid system where military courts handle initial proceedings, but civilian courts have a final appellate jurisdiction. Okay, we'll give it away. I mean, because now you're saying, okay, there's a possibility of now going to the civilian court, but how much trouble people have gone through in between, and then the practical and legal reactions, the NRM Parliamentary Caucus in the meeting on 21st February, the ruling MP largely supported amendments to the UPDF Act, and that is something that we are debating with as a country today. So the human rights organizations, groups like Human Rights Watch and Uganda Law Society have actually criticized the move, calling it a blunted disregard for the Supreme Court ruling. Yes, and the advocates on the other side will say, no, we are simply obliging with what the Supreme Court has actually provided in light of the justifications or in light of the substantive changes that need to be seen. The Attorney General's response, while the Attorney General stated that the government is actually complying with the Supreme Court ruling, he suggested that legislative amendments could actually provide, in their opinion, a balanced approach to handling military-related crimes involving civilians. And that is something, again, you may want to look at in terms of that particular dispensation. Yes, now, let me take you a little bit deeper in light of the key constitutional and legal challenges that may befall or that we're likely to face as a nation in terms of the discussion that we're having today. Number one, the proposed amendment raises several legal and constitutional concerns. Yes, and perhaps that is food for thought in terms of the challenges that we're likely to face as a country, whether legally or constitutionally. In terms of the violation of the doctrine of separation of powers. Yes. We all know what separation of power means. And Uganda's constitution, particularly Article 126, guarantees the independence of the judiciary. And that is something that it should be very fundamental, and we should all understand it in light of that. And that having been said, Parliament, in terms of amending the Imperative Act to counter the Supreme Court's ruling, could actually be seen as undermining judicial authority, and that is something that that we're likely to see that is substantive in light of the development for the country that we are living in today. And then the argument in terms of a right to a fair trial, that also is something that is possibly going to be in question. When you look at Article 28, Sub-Article 1 of the Ugandan Constitution, and the international treaties such as the International Covenant on Civil and Political Rights, what they call the ICCPR, they guarantee civilians the right to be tried in an independent and impartial courts. And we all know that, quote unquote, that most of these military courts are obviously not that independent when it comes to civilian or what issues, less even military, just to say the least. So military courts are being under executive control. They lack the judicial independence and cannot guarantee fair trials for civilians. And that becomes extremely important in light of the discussion today also. And then there could be aspects in terms of what they call potential breach in light of Article 92 of the Constitution. Yes, when you argue in light of Article 92, explicitly prohibits Parliament from passing laws that actually overturn judicial decisions. Yes, and that is where their hands are a little bit tied in light of that. And the proposed amendment could actually be challenged on what? On grounds that the law that they are actually attempting to bypass a Supreme Court jurisprudence by doing that. And that is something that we may likely to see in terms of the constitutional debates that are likely to ensue out of the so-called proposed amendment. And then the aspect in terms of what they call comparative international jurisprudence in light of comparative analysis, for example. Uganda's legal controversy mirrors similar cases, for example, in Kenya, Nigeria, and even in South Africa. And in doing so, let me give, for example, a base or an argument in light of Kenya, for example. In Kenya, the High Court in David Ngugi and others versus Attorney General, which was a 2019 case, ruled that civilians must not be tried in military courts, reinforcing the constitutional right to a fair trial. And that is something you cannot take away in light of that particular argument. So even when we do a comparative analysis, we have got substantive cases that are played out. In Nigeria, for example, in 2021, the Nigerian Supreme Court struck down military trials of civilians, emphasizing that military courts are meant for armed forces discipline only. And that's something, again, you must contextualize in terms of what we're talking about today. And yes, we could also have particular cases also that are played out in light of South Africa, for example, in light of the post-apartheid constitutional explicitity, which prohibits military courts from actually trying civilians, citing past abuses under military rule. So those are some of the playouts that I would have loved to argue. But then the point is that these international precedents further, in my opinion, weaken Uganda's legal basis for attempting to introduce military trials for civilians. Whether we are making the discourse in light of fearing that these people hide under the civilian entity, yet they are militants, is a question of debate. But for purposes of it is a thorough and conclusive discussion, I would argue in terms of constitutional position. Yes, in terms of comprehending, for example, with the Supreme Court's ruling being final, and therefore must be respected, because that is the law of the land. It's fundamentally important. It lays good precedent for us to follow without causing an abrogation or constitutional dodges, if you like. So the Parliament, in my opinion, should not pass a law that actually contradict constitutional provisions or judicial pronouncements, because that would set a bad precedent in light of other things that may ensue at later date. So we need to comprehend and understand what we're talking about. And then also the need for civilian oversight in terms of security-related cases. That also becomes extremely important. We need to understand that from the word go. If, for example, the government is actually concerned about national security, threats in terms as an alternative approach could be variant. We could look at it in variant different ways. For example, strengthening civilian courts' ability to handle terrorism and even military-related offenses. And we could do that. I mean, we've seen judges who are actually affirming their independence in terms of executing their mandate. So establishing special security tribunals within the civilian judicial framework could also be something that you would think about as food for thought. Yeah, so that we could have that without necessarily compromising the what the independence of the judiciary, but also without infringing on the rights of civilians as their rights would ensue. Not so. And then upholding judicial independence. As I said, the executive must not interfere with judicial rulings by using legislative amendments as a tool to circumvent unfavorable court decisions. And that's why we're seeing, and that's our worry, because we are saying, wait a minute, and these guys trying to circumvent so that we can create, another, law that bypasses the other one. So, and then the argument of public and even civil society engagement. Yes, perhaps it's high time that the civil society, and in light of organizations, opposition parties, and even legal scholars, should actually be actively engaged in terms of discussions on how these proposed amendments could actually ensue, rather than simply, selecting a privileged group, to use those words sparingly, to be able to decide on behalf of the fatalities or obligations that befall quite a number of people. So if the government proceeds with the amendment of the UPDF Act, challenges could actually be pursued in both Ugandan courts and even regional human rights bodies. Yes, and the legal battle, in my opinion, presents a defining moment for Uganda's constitutional democracy, and it tests the strength in terms of judicial independence and aspect of separation of powers, and then their adherence to human rights standards. So the outcome, my friends, is in this debate will shape Uganda's legal landscape for years to come, and that is something we need to understand again from the word go. I would have loved to go a little bit more, but in the interest of time, I would like to thank you, my viewers, and God bless you. Thank you once again. My name is Isaac Christopher Lubogo. Find our books at lubogo.org. Amen.